Oh, okay, we're going to move on to chapter 35, which is the management structure of corporations. So, there are three different types of people that are involved in the management structure of a corporation. You have the board of directors, you have the shareholders, and you have the officers. Sometimes this is shown by an illustration in the form of a pyramid. You can actually do it in different ways. So I don't really care how you know who's on top, but I want you to know what each group's role is. So the board of directors in any corporation basically guides where the corporation is headed. They drive the vision of the corporation. They also select and hire the officers of a corporation. What do the officers do? The officers are the ones that run the day-to-day operations of a corporation. So the board of directors hires the officers. But who, pray tell, selects the board of directors? It's actually the shareholders. So the shareholders vote on who the board of directors is. So it's kind of like what came first, the chicken or the egg. That's why I don't really care how you line it up. I just want you to know what each group's role is. So again, board of directors, they are the visionaries. They manage or guide the corporation, and they also hire the officers. The officers manage the day-to-day operations. They get paid. Sometimes board of directors do not get paid. And finally, the shareholders, they select who the board of directors are, okay? One of the greatest burdens that is on corporations in general is the rigidity of their compliance with their rules. Why? Because they have to follow the rules, especially if it's a big corporation. Otherwise, they erode that protection that the corporation gives them from personal liability. Okay, what is the role of shareholders? Now, we already said that the shareholders, what their role is, that they elect the directors. So the role of shareholders, write this down. Role of shareholders, they elect the directors. They approve certain extraordinary matters. They approve corporate transactions that could be void or voidable. And they have a right to enforce these rights. So, what does that mean? Election of the directors, easy enough. But why would they have to approve certain extraordinary matters or corporate transactions that could be void or voidable? Think about it. The reason that a board of directors or officers would have the shareholders vote on extraordinary matters is to really cover their behinds, because they can say, hey, listen, this was something out of the ordinary, but the shareholders voted for it. They wanted to do it. That way you can't go back and sue the board of directors or the officers for doing anything that may not be a traditional course of business. Why? Because the shareholders voted on it and they approved it. And the last one, which means the right to enforce these rights, is just the ability for shareholders to sue the board or officers if they're not doing what they're supposed to do. Generally speaking, when we talk about voting, the voting is you get one vote per one shareholder unless the articles of incorporation say otherwise. Now, this next thing is really interesting. I'm going to talk to you about quorum and voting. And I might have mentioned this before, I can't remember. I think I did mention it in one of the previous lectures. Quorum and voting is really interesting. So let's say your board of directors has 10 people. I'm sure I talked about this, but I'm going to talk about it again because it's so cool. So your board of directors has 10 people. You set in your bylaws that in order for you to carry out any business, you vote on things or vote on minutes, approve transactions, anything like that. You need to have a simple majority present in order to have quorum so you can conduct your business. Because if nobody shows up, then what are you actually voting on? There's nothing there. So a simple majority out of 10 directors is what? You got it, 6. So 6 out of 10 show up. Now your bylaws also say in order to pass a motion, you need a simple majority of quorum. What is a simple majority of 6? 4. So you have a board of 10 people, but you only need 4 to pass things. Isn't that crazy? So it's important, if you're going to be a director, you need to be involved, you need to be present, because then only a few people can actually really shape now where the corporation is heading. I've served as a director on many organizations, and I take this stuff seriously. Why? Because your name is going on there. You're voting. So you're guiding where an entity is going. So you have to make sure you're on top of that. So that's quorum and voting. Election of directors and removal of directors usually happens at the annual meeting, but removal can be done actually also like as an emergency. So if you send out an email to a group of people that you want there that are going to vote your way, right? Maybe your bylaws say 24 hours to have an emergency meeting. Meanwhile, you know very well that most of your board is different states, they have jobs, they're not going to be able to make it. You'd be actually able to remove a director by doing that. Sending an emergency email if your bylaws allow it, calling a meeting, having the minimum people there to have quorum, 6, and then having your 4 people there to pass that along. So just, be careful. What does proxy mean? Proxy is you allowing somebody to vote on your behalf. So I'm not going to be there at this particular meeting, but I nominate John Smith to be my proxy, meaning John Smith is able to vote my shares and my voice whichever way he does. Now, I can tell John Smith how I want my votes to go, but whether or not he'll listen, I don't know. But if I'm giving him a proxy, that means he can vote on my behalf. He can vote whichever way he wants. So when people usually use that mechanism, they're giving it to people who are like-minded with them that are going to vote typically the way that they would vote. Gawler versus Gawler. You need to know that case. It's going to be on your final exam, some shape or way or form. And it's about a small company, right? Now, I want you to read this one, so I'm not going to give you too much information because I want you to read it out of your textbook. Stop searching the internet and using all these weird sources to get your information. Read it from your textbook. That's why it was assigned to you. There were 2 brothers who did business together, and they had a contract between them that said if one of them died, their wife would become the business partner. One of them dies. Now guess what happens? I'm not going to spoil it for you. You're going to look it up and you're going to read it and you're going to see what happens. But you need to know that case. Okay, direct suit and derivative suits. So sometimes shareholders can actually sue the company, right? So we talked about Dodge versus Ford a little while ago. The Dodge brothers sued Ford so they can get their dividends because the board was not doing what they were supposed to do. So a direct suit is when shareholders try to make a corporation. They're suing the corporation to do something that they were supposed to do. A derivative suit, however, is when a corporation itself, like the board, they're supposed to do something and they don't do it. So then the shareholders are forcing them to do what they were supposed to do. So it's different. So when you have a direct one, I'm going to say it again. When you have a direct lawsuit, it is when the shareholders are suing the board because they're not paying out dividends, let's say. They're not doing something that they're supposed to be doing. A derivative is when the shareholders step in to the role of the board of directors and do something that the actual board wasn't doing. A little fuzzy, but that's really how to best way I can explain it. Like with a derivative, the shareholders are trying to enforce a right that belongs to the company. They're trying to protect the company by having the company do something. Let's say the company discovered that one of their directors was engaging in fraudulent activity, but all the other board of directors, they don't want to rat out their friend, so they don't do anything. But the shareholders can file a derivative suit where they're forcing the board of directors to eradicate that one person that's doing fraud. Okay, hopefully that kind of helps you. Don't worry about that. The last thing I want you to know for chapter 35 is the business judgment rule. And the business judgment rule is really a fun thing. I think it's fun. It basically says as long as you try your best you cannot be sued. You can still be sued, but you would prevail. So as long as you're trying your best, a business judgment rule says that as long as you're doing things conscientiously in your fiduciary capacity, there's no fraud, there's no undue influence or anything like that, your judgment stands and it's good. And you will not be sued. Like, let's say you make an investment, but the investment goes down south. You can't be sued for that because you don't have a crystal ball. You don't know whether or not the investments are going to go up or down. You hope it's going to go up. You've done your due diligence, but you can't be sued just because the company doesn't do well financially as long as you tried your best. Okay, so that's the business judgment rule. And that's it for chapter 35. That's the only stuff I want you to know. And then the only thing I want you to know for chapter 36 is what a merger is. And a merger is just the bringing together of two or more corporations where they become one. So a merger is when two companies that are separate, they become one. They consolidate. Now they share people or they fire people, but now they become one entity. Okay? And that takes care of all the stuff I want you to know for chapters 35 and 36. I'm going to do one other segment about your final exam, and that will be it.